da Arizona State University. Sua pesquisa investiga o acesso à justiça civil sob todos os ângulos, desde a forma como os serviços jurídicos são oferecidos e utilizados, passando pela organização da assistência jurídica civil em todo o país, pelo papel da atuação pro bono e a eficácia de advogados, não advogados e ferramentas digitais como assessores e representantes, até a maneira como as pessoas comuns percebem seus problemas jurídicos e buscam solucioná-los. Além de seu cargo na ASU, atua como Faculty Fellow na American Bar Foundation, onde fundou e dirige a Access to Justice Research Initiative. Para gravar, tá? Pessoal, a professora Rebecca é uma referência hoje no estudo do acesso à justiça, nessa perspectiva bottom-up de que falávamos, né? Então, é uma grande alegria para a gente ter ela aqui. Quem quiser fazer perguntas, dialogar com ela, vão anotando para que vocês possam fazer isso. Ela é muito aberta ao diálogo e ela está super à disposição para dialogar com a gente. O tema da palestra dela é Access to Justice and Vulnerabilities, Use Empirical Evidence to Guide New Directions. Professor Rebecca, good evening. It is a great pleasure to welcome you to our event, the first Congress on Access to Justice, the Mobilization of Law and Vulnerabilities, and the launch of our Human Rights Clinic. Our project seeks to engage with vulnerable groups in Franca, where our university is located, to listen to them and together build solutions to the challenges they face in realizing their human rights. Early today includes, we met with some of these groups, so your lecture takes place in this very context. Thank you very much for accepting our invitation. Please feel free to speak for as long as you wish. Thank you, Professor.
Thank you so much. It's such an honor to be invited to join you today, and I'm delighted to be able to talk with you. I wish I were there in person. I was in Brazil last week, and it was wonderful to visit, but it's wonderful to be here this way also. I'm going to share my screen if I can figure out how. Let's see here. There we go. All right. Yes, there we go. Okay. Now, can I make it do what I need it to do? Let's try this differently. Now let's try this. Maybe that'll work. All right. Can you see it?
Yes.
Okay, great. So I'm going to talk mostly about some research that's coming out of the United States and other contexts about how people understand and experience their justice issues, but also about how those access to justice issues relate to different kinds of vulnerabilities. But since we're being hosted at a law school clinic, I thought it might be interesting to share some findings from some work I did several years ago on the way clinic experiences shape lawyers' careers, at least in the US context. And the work that I'm going to talk about today, some of it I did on my own, but a lot of it I did with other colleagues, including Matthew Burnett and James Tufel, who are at the American Bar Foundation, and Jeff Selbin, who's at the University of California, Berkeley. And of course, none of us can do things without all kinds of support. And so I'm grateful to the financial support from the different sources that have contributed to these different projects. So I want to talk just a little bit about how clinical experience shapes law careers. And then I want to talk about some things that it might be useful for aspiring lawyers to know as they think about how to redesign justice around what we understand people's needs to be, or what our growing understanding of people's needs is. There are a couple of ways that we can think about clinical education as playing a role in increasing access to justice. And one of them is, of course, through direct services. In the US context, that's not a particularly big contribution. So the typical number of cases served by the average US law school clinic is 4 every year. So they're not having an enormous impact in terms of the number of people that they serve. Sometimes they do, though, quite high impact litigation around environmental issues or work issues, something like that. So that's one way that clinics might shape access to justice. But we also know that they there are a particular way of training lawyers that may have good benefits that other ways of training lawyers don't have. In the United States, law is a postgraduate degree. So you go to college for 4 years and then graduate from college, and then you take a 3-year course in a law school as an additional credential. And there's been lots and lots of reflection and study about legal education in the US context and in other contexts. And one of the things that tends to come up over and over again is that law school training is really good at helping people understand how to think in certain ways, how to think analytically. But they're not necessarily very good at helping aspiring lawyers know how to practice law when they get out of law school. So you couldn't open a practice immediately and start doing things often. And there's some concerns that if lawyers have a special role in society, if they're important stewards of important values, there are some questions about how good law school is at cultivating those values that we want lawyers to have in terms of their public obligation or a civic dimension. So experiential education, of which law school clinic practice is one kind, is meant to be kind of a way of addressing some of these failures that many people see in legal education. So we know that when people take doctrinal courses, so courses about like what the law says and how to interpret it, that, at least in the contexts where this has been studied in the North, students learn how to be abstract and how to stay away from moral questions, stay away from social contexts. They tend to work very analytically, going back to that idea that law schools are good at teaching analytic thinking. Doctrinal courses tend to contribute to a general tendency that you see again in the North of law school training, sort of taking people who might come in with commitments to work for social justice or for the public good and kind of diverting them from that to being other kinds of lawyers. And if you ask lawyers how they feel about doctrinal courses in law school, they don't feel like they help them prepare enough for the practice of law. So again, experiential education is a way to respond to some of those things that are missing from just the doctrinal curriculum. And I just want to share a few findings from the US context from a study that was called After the JD. And what this was a longitudinal study of American attorneys that looked at their career outcomes, and it followed a bunch of people who became eligible to practice law for the first time around the year 2000. And I'm going to speak to findings from the first couple of waves of that survey. So these are people in the early years of their legal careers. One of the things that you see is that recent law graduates really value clinical education. And at law schools in the US are very stratified. So a place like Harvard or Stanford is very elite. And then schools that are not those fancy places are less elite. And particularly students from less elite law schools really value clinical training because in the US context, they're the ones who are most likely to go into practice working with people. The other thing that we see is that participating in clinic during one's time in law school is associated with a greater likelihood of some kind of public service employment once you graduate. And that's true, even though, people might enjoy participating in clinics because they come in with different values, and indeed they do. But even once you control people's kind of retrospective understanding of why they went to law school, clinic participation seems to support those kinds of public service careers. And I just want to share a couple of findings about this. So if you ask early career lawyers, what was the most helpful aspect of your formal law school curriculum in making the transition from law school to working as a lawyer, the one that they rate most highly consistently is clinical training. The things they rate higher than clinical training are not part of law school curriculum. They're experiential education through work, right? So they're having a summer job, working in a law firm or a legal employment setting, having a job during the school year where you're learning to use law by using law. So clinical training is this wonderful opportunity that students really appreciate for learning how to do law hands-on and for real. The second thing that you see is that if you control for why people came to law school, as well as things about them that might shape the way they would feel about different kinds of issues or engage around different kinds of things, so their race, their social class background, and their gender, what you see is that, at least in the After the JD, law graduates who participated in clinics were a third more likely to be in public interest jobs in their early career than lawyers who didn't. So there's some sense that these are really valuable experiences that people really take a lot from, and that they also may shape them in ways that shape what the legal profession would look like because people have participated in clinical education. And I just wanted to share that because we are in a clinic, and it's interesting to think about how clinics have their effects and what their impacts are on. And now I want to talk a little bit about what it might be useful for people who are coming out of law school and out of clinical practice and into practice to know about the way people think about and understand their justice issues. Because if you look across all of our justice systems, the Brazilian justice system, the US justice system, lots of others, they have really significant challenges meeting the needs of the populations that they're supposed to serve. And one of the things that I think many of us are thinking about is how can we redesign justice from the ground up? And that's going to be the task of graduates from your law school and from other law schools as they enter practice. So I want to share some evidence from people-centered perspectives on how justice issues are experienced. And a lot of this evidence comes from legal needs surveys that investigate ordinary people's experience of problems that are institutionalized in law as legally actionable or as justiciable. And legal needs surveys really became very popular about 20 years ago, and there's been an explosion of them since then. And one reason that both researchers and policymakers like them is that they're a great way of providing a national picture of the way people are experiencing justice issues that's more comprehensive than just looking at the records of a court system or something like that. It lets you see what's flowing into courts and what's not, who's getting assistance and who isn't. So it's a very valuable way of understanding what's happening with people and with their experience of justice. And a lot of the contemporary studies are based on a model that Hazel Gann, who's at University College London in the law school, developed in the late 20th century. And so these surveys ask about, if you ask people about legal issues, they think of a very narrow set of things. So they think of things where they understand that there's some legal process. Like everyone knows divorce is a legal issue, but not everyone understands that wage theft is a legal issue, or that being sued for debt is a legal issue. So these surveys, instead of asking you, do you have any legal problems? They ask you, are you 2 or more months behind on your rent? Does your employer owe you overtime or extra holiday pay that your employer's not paying, et cetera? So you just ask people whether they've encountered a specific set of problems, and then you ask them, well, how did you try to handle that problem? What you see is that, of course, national jurisdictions and even within countries, regions can be very different from each other, but there are some very consistent patterns across the 150 so jurisdictions that have been studied. One is that lots and lots of civil justice problems happen everywhere. They happen to all groups in populations. And even though they go under different names in different jurisdictions, they're very commonly around consumer activity, around relationships of different kinds, around making a living, around spending the money that you make, or dealing with credit and debt, and around shelter. Those are just very common problems in every kind of country in the world that we've studied. And we also know that in every country in the world that we've studied, people face barriers to successfully resolving or lawfully resolving those issues. And sometimes those barriers are about the information and understanding that they have or have access to. Sometimes those barriers are about being able to just take the action. So do I have to take off work to go to court, for example? Do I have to travel? If I'm in a rural area, do I have to travel a long way to find a source of resolution for my issue, and so on? And then, of course, there's cost. There's the cost of taking the action itself. So I might need to pay for a lawyer. I might need to pay a filing fee. But there's also the cost the costs of turning something legal. So oftentimes the justice issues that people experience emerge in relationships, a relationship with your employer, with your neighbor, with your spouse, with another family member. And so one of the costs of using law can be damage to those relationships or threats to those relationships. So people think about those around the world as well. The World Justice Project in 2019 put together kind of an atlas of legal needs surveys that had been done in a range of countries around the world. And so these are some data from Brazil. So if you're looking at this information for Brazil, you have about a bit over 2/3 of people who are experiencing a legal problem within the past 2 years, within the 2 years of the survey. And if you extrapolate that up to the population of Brazil, you've got about 110 million civil justice issues emerging every couple of years. So there's a lot of civil justice activity. And as you can see from this graphic, the most common places, the most common kinds of issues people have are consumer issues, family issues, housing issues, issues with education, issues with money, and issues with public services. And if we're thinking about this in the context of rights, some of these are human rights issues, some of them are social rights issues, and some of them are just issues of contract, right? But so there's some really critical life areas in which these problems are falling.
Professor Rebecca.
Yes.
Sorry. I'm sorry.
I'm sorry to interrupt you, but we are not seeing the presentation.
Oh my gosh.
Okay, no problem.
Well, let's see.
Okay.
So I can see it.
Yes, we can see, but don't move it. The slide.
It was frozen.
Professor, you are sharing another window.
All right, let's try this. Let's try something different.
Sharing slide presentation. You are sharing another window.
I don't know.
Excel window.
Now we are seeing people reach widely.
People reach widely, but most do not get help. Is this slide? It's 21. The 21 page.
It's the wrong window. You need to share slide presentation. I'm sorry.
All right. Let's try this again.
Sorry, Professor.
So here we go. Thank you for stopping me.
Yeah. I'm sorry to
I'm
interrupt.
sorry.
Oh, no. So here we are. There we go. It's sharing a window.
Okay,
Yes.
yeah.
Now, how do I make it advance? That's the problem.
Please move the page.
Try to go to the next slide.
So I can't. Is it moving?
No.
Yes.
Yes.
Now, yes.
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 All
Right.
right. So you're seeing a presentation
Yes.
and it's moving.
Yes.
Excellent.
Thank you, Professor.
Oh, no, thank you. All right, so here's where we were. So folks in Brazil are experiencing about 110 million new civil justice issues every year, and they're falling in those areas that I was describing are common across the world. So consumer, housing, family, money and debt, access to public services. A lot of civil justice activity, and a lot of it in very critical areas of life. And then when Brazilians experience civil justice issues, they reach pretty widely. So they're going to friends and family, they're going to lawyers of different types, they're going to welfare or healthcare professionals, they're going to employers, they're going to religious communities, they're going to civil society. But most of them are not able to get help. So only 13% of the folks who reached out for help with one of those justice issues in this particular survey actually got any help in that case. So there's a big gap between people who may need assistance with their justice issues in Brazil and people who are able to get it. The other thing that we know in Brazil and elsewhere is that across the world, when people have civil justice issues, the formal legal system and formal legal processes and attorneys are pretty peripheral everywhere we go. So people are more or less likely to get and seek help in different countries. But when they do, most of that help is not coming from the justice system or from lawyers. And in the US context, one of the ways that we think about this is that if you have all of this civil justice activity, but very little of it is making it to the justice system, it's kind of like an enormous iceberg. So most of the iceberg is all of the issues that people are experiencing that lawyers and courts never see, which is most issues. And then the top of that iceberg is where the legal system sits and what it sees. So this is another reason these legal needs surveys are so valuable, because they show us what's underneath the surface in a way that the court system and the court system's records and lawyers' case records can't see, because those issues never reach them. One thing that we also know about justice issues is that they have collateral impacts, and this relates to vulnerability and precarity. So again, these are World Justice Project findings for Brazil. So of those 69% of Brazilian adults who had experienced a justice issue in the previous 2 years, over a quarter of them, in addition to the justice problem itself, experienced some hardship or negative impact as a result of or as part of that justice issue. So 20% of them experienced negative impacts on their health. The health impacts of justice issues that have nothing to do with health, the justice issue itself may not be health related, but the likelihood that it will have a health impact is quite high in many jurisdictions. These are very stressful events at times. About 12% of Brazilians lost money or employment or had to move home. So they had some kind of material economic impact. Of course, these things often happen in relationships or they implicate relationships. So about 7% experienced some kind of interpersonal challenge as a result. And then another health issue is substance use. So about 2% of these issues, people report that they developed problems with alcohol or drugs as a result of or as part of the issue. So these can have very, very serious collateral consequences. And there's an interesting set of studies. Again, this particular set of data is from the United States, looking at the ways in which civil justice problems compound inequality and the ways in which it can be valuable to intervene, and you can have sort of equalizing or welfare increasing effects from intervention. So again, there's lots and lots of civil justice issues, and many of them affect economic aspects of life. And they tend to cluster. So one of the things that can happen in the United States, if you say owe a debt as part of your as part of a criminal court case, is you can have the civil fine if you don't pay the debt, the civil consequence of having your driver's license suspended. And once you get your driver's license suspended, then you can't drive legally, so you can't go to work. You can't take yourself to medical appointments. You have a whole set of consequences that follow from that suspension. Consumer debt, of course, makes people's households insecure. And then they have to borrow more money to deal with the fact that they don't have very much money, which increases their insecurity. We know that tenants facing eviction are going to have a greater likelihood of entering into poverty and a longer period of housing instability, but we also know that they often start out with issues that lead to eviction. So these problems kind of turn on one another, and they create this vicious cycle. Similarly, they create collateral consequences. So if you can regularize your immigration status, your income will go up because you'll have access to different kinds of jobs and you'll have access to different kinds of job protections. If your benefits are denied unfairly, of course, you've lost the income of those benefits. Domestic violence, which is a common civil justice issue, leads not only to the violence itself and to the injuries and damage from that, but people miss work and they lose wages, so their income is affected by domestic violence. People who are evicted have worse financial health over time. So you just sort of get these big clusters of troubles. And civil justice problems aren't equally distributed. So if you are younger, if you have kids, if you have health issues, if you are not a heterosexual person, those things increase the likelihood that you're going to encounter civil justice issues. Race, not being white, increases the likelihood that you're going to encounter civil justice issues. So you have these things that have negative impacts, and those events with negative impacts are falling more heavily on people who already are excluded or suffering in other ways. And then we're also getting some evidence that when you start to take action on those problems, that can improve economic stability and mobility. And we see that if you're looking at eviction. We see it if you're looking at access to benefits, so helping people connect to the benefits that they're entitled to. We see that if you look at domestic violence, And we see that in the US context if you look at criminal record expungement. So at least in the US, if you have a criminal record, it can restrict your access to housing, to employment, to different kinds of benefits, to different kinds of subsidies. And if you can, expungement is a civil legal route through which you can erase the public record of some kinds of convictions. And being able to do that for someone opens up a lot of opportunities for them that were closed by that criminal record. So when you can act on some of these issues, you can really act on precarity and vulnerability. The other thing that we see across countries is that there are common patterns of inequality. So as I noted, groups that are already disadvantaged are more likely to experience civil justice issues of different kinds, and they're more likely to have the negative consequences of those issues, whether those are material negative consequences like loss of income or losing your housing, or psychological consequences like mental health issues, but also a loss of confidence or a loss of belief in your own ability to solve problems that you confront, or a loss of trust in public institutions. So those consequences are unequally distributed also. And we also know that not everybody has access to the same kinds of assistance. So people often don't see that their justice issues are legal, nor do they necessarily see that they are things that they can do anything about at all. Some people are better and other people are less able to take action on their own behalf. So people differ in their legal capability is the term that's being used for this. And the other thing that we see is that experiences with justice issues can accumulate so that various communities in an unequal society can develop shared understandings that don't always support the most effective responses to justice problems. So for example, if my community is constantly being harassed by the police, we may all in my community decide that really law isn't a source of solution for other kinds of problems that we face either. Or if we're repeatedly frustrated, if I and my neighbors are repeatedly frustrated at trying to work on an issue, we may decide that there's no point in working on these issues in any way, right? So these kinds of things can create unfortunate cycles of also inaction or withdrawal that can be unhelpful in helping people deal with their justice issues. It is really striking that people don't recognize the legal aspects of their justice issues, and that's one of the most important reasons that they don't go to legal help. And you can see this in surveys where you ask people, okay, you told me you had a particular kind of problem. Your employer wasn't paying you all of your wages. You're 3 months behind on your rent. You've applied for a benefit and it's been denied. What kind of problem is that? So is it a legal problem? Is it a private problem? Is it a bureaucratic problem? Is it just bad luck? Americans are very religious, so we ask them also, was it part of God's plan for you? And what you see, looking across 94 different kinds of civil justice issues, is that the most common way that at least Americans understand them is as bad luck or part of God's plan for them. So as things that just happen or that are just a part of life. And if I think that my employer not paying me overtime, or my inability to stay in my apartment, or my difficulty with a neighbor is just part of what happens, I'm going to respond to that issue very differently than if I think about it in a different way. There's another group of problems, about a fifth, that people understand as being the responsibility of somebody, but not of a big public institution. So they're a community problem or a private problem or a family problem. There's an us maybe that should be working on this problem, but it's not the law. And it's for less than 10% of problems, at least in the United States, that people see the legal aspect of that justiciable issue. So when we're thinking about designing services that people can connect with and interventions that they can connect with, branding those interventions as legal isn't going to connect with most of their own understanding of the issue. The other thing that we're finding, both from research in the US, but also from a really wonderful study out of Australia called the Public Understanding of Law Survey, people often feel like they understand their justice issues even when they don't. So in that study I was talking about just a moment ago, where we went around a city and asked a bunch of people about their experience with justice issues, when people said, well, I didn't go to anyone for help with my eviction or my divorce or my domestic violence problem or whatever. I didn't go to anyone for help. We ask them, well, why not? And what you see is, sometimes it's too stressful. Sometimes people don't know where to go. Some people are worried about how costly it will be. But the most common responses are that I understand this situation and I know it wouldn't make any difference if I got help, or I understand this situation and I don't need any help. I've got this. And of course, some people are right when they say that it wouldn't make any difference or that they don't need any assistance, but sometimes they're not. And the public understanding of law surveys out of the Victoria Law Foundation really have a great texture of who understands and who doesn't understand. And it's surprising. It's not the most excluded people who necessarily have the least understanding. There are quite privileged people, at least in Australia, who misunderstand what their options are with justice issues, and they're overconfident. So there's a question about how to connect with people who may misunderstand how well they understand their own situation. The other thing that we know from lots of different surveys is that when people seek help, they go to trusted sources. If you look at that American survey, there's a chunk of issues for which people do nothing. The most common way, and this is true in many jurisdictions, that people handle justice issues is by doing something themselves. So this graph calls that self-help. But when people reach out, the first place that they reach out to is their immediate social network. So they reach out to family and friends. And so that also tells us that when people are in trouble, they go to people that they trust. They trust themselves and they trust their friends and their family members and their neighbors. And so thinking about how to build trust into justice services is an important part of thinking about how to make them accessible. So when we think about that evidence about how people think about and understand their own justice issues, what's that?
I'm sorry to interrupt you again, but again, we're not seeing the slides, the presentation, and the graph.
I don't understand. I didn't change anything. Well, I'm almost done. So let's see if we can show this last slide. Can you see a slide that says timely, targeted, trustworthy, and transparent?
We're seeing a slide
41.
Great.
42.
Page 42.
Okay, let's try one more time. I'm sorry for all this trouble. Here we
That's
go.
okay.
All right. So can you see a slide that says targeted, timely, trustworthy, and transparent?
Yeah, you're seeing.
Okay. So this is the last slide. So I'll just speak to it from here. So if you think about what we've learned about how people think about and act on their justice issues, and if you're thinking about redesigning justice to respond to what we know about people, so redesigning it from the ground up, what you see is that there are 4 qualities that accessible services have. So they're targeted. So they're specific to whatever it is that person is experiencing, and they're offered to them in a way that makes sense given the way the person understands the issue. So free legal help here isn't actually particularly targeted, and doesn't necessarily connect with all of the people who don't understand that their justice issues are legal. So thinking about how to target services so that they offer people what it is they need to resolve the issue in terms that people understand turns out to be very valuable and important. A second thing that's true of effective and accessible services is that they're timely. So they show up when people realize that they're in trouble. Sometimes we have this wish to do public legal education, say in grade school. And there could be lots of there could be lots of good reasons to do public legal education in grade school, but it's really unlikely that someone who's being evicted when they're 35 is going to remember what they learned in the 8th grade about eviction law or something like that. So when you want to have a service or an intervention, it needs to show up when people are in trouble in their adult lives. we also know that it's important that these services be trustworthy and from some source that people believe in. And there are different ways to cultivate that kind of trustworthiness. So one is to collaborate with partners, if you're a law providing service, to collaborate with partners who are already trusted. So that could be community organizations, religious organizations, community unions, lots of different kinds of things. Another is to try to build that trust yourself as a legal intervention that's new to the space. That can take longer, but there are ways to do that, of course. And then finally, people in these situations are under stress and facing potentially significant consequences. And so they really want services that are transparent. So they want to understand, what is the situation that I am in, and what is it that's going to happen to me? What are my choices? What happens if I make the first choice? What's likely to happen if I make the second choice? And so as you enter law practice and you start to think about how to do justice work for people, sort of thinking about how to connect with them where they are at the time when they need things, with just what they need and not lots of other stuff, through some means that they trust, and in a way that can communicate to them the situation that they're in and what their choices are, so they continue to have some agency and information. Those are really key things in thinking about how to redesign justice. And so that is what I have to share with you today. I'm sorry again for these technical problems. I don't know what's going on, but I hope that some of this has been interesting and might be useful, and I look forward to a conversation with you now.
Thank you so much, Professor. It's wonderful. And I would like to invite Professor Maria Elisa to participate in the debate. And Professor Rebecca, how do you imagine that the activities of the Human Rights Clinic can contribute to research on people-centered access to justice? It's possible.
I think that's a great question. I think that's a really exciting opportunity. So, part of what you're doing in a clinic is working with actual people and their actual justice issues, or groups and their justice issues. And it's an opportunity to gather information about their experience and what they think and how they would like to connect with law. I think that's an amazing research opportunity. Another amazing research opportunity is you're doing law. And so can you study the impact of your practice and the conduct of your practice, and then take that information to modify it a little bit so that it becomes more effective? Or to take that information, one of the things, I'll give you an example from the US legal aid context. So one thing that any legal services provider has to decide, because you can't do everything, is what kinds of cases are we going to take and what kinds are we not going to take. And if you're in a clinic, you have a range of reasons for doing that. So part of what you're doing is training. So there are pedagogic reasons for choosing cases, but there will also be impact reasons for choosing what cases or areas of law you're going to work on. And one thing to think about is, can you get information about the needs of the populations that you want to work with, and think about the most impactful places where you can act. And I'll give you an example from the US. So there was a practice in mortgage foreclosure that a legal aid agency in Ohio was doing, and they could serve very poor people, somewhat poor people, and low moderate income people. And their goal in doing the foreclosure practice was to maintain people's housing, to keep them in their homes. So they did a study and they asked, okay, we've done this foreclosure practice for you. We've defended you from foreclosure. Let's look at a year later and see if you're still in your house. And what they discovered was that they could never retain housing, even though they could successfully defend for the foreclosure, they could never retain housing for the poorest group they were serving. And so they made a decision, which was, well, if we're not achieving our goal in practicing this law with this population, then let's not do it. Like foreclosure isn't the way, foreclosure defense is not the way to solve the problem that they're experiencing. So let's take that energy and put it somewhere else. So I think that's another really interesting opportunity to think about how to use what you're learning from your practice to target your interventions or your activity where it's most likely to be impactful. And it will, you know, there will sometimes be surprising results about where that is, but that's a great opportunity. And I hope in the research that you will be producing out of this clinic, you will be publishing. Like, it can help you figure out how to do your own work differently or better, but I think it can also educate the world about how to do this work differently and better. So I hope that you will be sharing it as you produce it.
Hi, Professor Rebecca. Firstly, I want to say that it's an amazing pleasure to listen to you, to listen your experience about empirical studies about race, gender, and class inequalities. And I'm a professor here in Unesp, and I want to know about if do you understand the role of a law clinic is direct the results of your empirical research to institutions to propose legislation changes and judiciary policies. Do you understand that is the role the law clinic?
So that is the role of your human rights clinic?
Yes.
Or are you asking me, do I think law clinics should do that?
If the law clinics can do that.
I think absolutely.
Yes.
Because your law clinics are wonderfully positioned between understanding the law and actually using it. And so they're wonderfully positioned to gather the kinds of intelligence about the way law is actually working, to be able to go back to lawmakers and say, you know what, for you to achieve your policy goal, or for us to have equity, or for us to have a society that everyone can participate in, this has to be changed. And so part of what you discover through your practice is what those legal innovations, statutory innovations should be. So I think absolutely. I think it's a wonderful opportunity of what you're doing.
And the results of all of our empirical studies, did you can you take the results in legislation changes in United States? You can you share with us some experience of legal change that empirical studies can propose?
Absolutely. I think one really good example comes from the world of, we call them fines and fees. So if you have involvement with the criminal justice system, you often end up paying a range of fees that are civil fees to the court as part of your punishment. So you may or may not be incarcerated, but you have to pay the fee for processing the fact that you're going to be incarcerated. You have to pay the fee for the restitution of your driver's license, all this kind of stuff. And one of the things that American researchers have been able to show is that there's no deterrence benefit to those fees. They keep people poor longer. They keep people engaged with the criminal justice system longer. And so there are a range of jurisdictions in the United States where state legislatures, because that's the level at which that decision would be made in the US, have changed the law around what fines and fees criminal justice systems are able to levy to prevent some of those negative consequences that no one wants, right? It becomes socially costly as well as costly on the person who has to bear all those fees. So I think that's a really important area. I think another area that's also at the nexus of criminal and civil justice is the research that shows the benefit of being able to remove certain criminal convictions from a public record. so that people then can have access to employment and housing and different kinds of benefits. So I think there's great scope for that to happen. You also see it around eviction, although how our understanding of how costly and harmful evictions are, that's a harder thing than just changing a law, because it's often related to things like affordable housing. So how can it's harder for jurisdictions to think about how to solve that problem, but all of the research and evidence about the harms of eviction are making them try to think it through, even though it's a more complex thing than just a legal change. I think another thing that we did that you might think about, so the dream is to take your empirical discoveries and get the law altered so that it makes sense and works more effectively and achieves the goals that we want. But another way to think about communicating research evidence to policymakers, a couple of years ago, and what we did was bring together, so we have federal agencies that are in charge of like housing and education and veterans affairs and things like that. And we brought together people from those agencies in Washington, D.C., at the US Capitol, and we paired them with researchers who were studying things whose research was relevant to the goals they were trying to achieve. So the goals of affordable housing, or the goals of criminal reentry, or the goals of access to healthcare. And we tried to set up, basically you're trying to get people to form relationships so that this flow of information back and forth between policymakers and researchers. And so you might think about that as a way of doing it too, because part of how you can achieve changes in legislation, statutes, but part of how you can achieve change is by helping people who administer policies understand the ways in which they're not achieving their goals because their policy is not working right, with the implementation challenges. And that's another way in which you can increase access to justice around really important issues that affect vulnerability and precarity.
Thank you. Alguém quer fazer alguma pergunta?
Alguém quer fazer alguma pergunta? A question of a student, professor.
Wonderful.
Ou se quiser fazer em português, a gente traduz.
Good evening, Professor. I'm Ellen. I'm a law student at Unesp, and I'm a little nervous. It's been a while since I spoke English, so I'm sorry. I was actually wondering, on a more personal note, we were talking about your experience in sociology, and I was really thinking about how did the idea of researching access to justice came about to you. In my case, I'll give you a personal example. I take great interest in access to justice and civil justice, but I also come from a blue-collar family, so it's very common for me to see that people sometimes don't know how to formulate their questions to a lawyer or a judge or anyone who has actual power to help them. So I was wondering, how did that come about? How did you become interested in access to justice from this perspective, the bottom-up perspective? Thank you.
Thank you so much for that question. So when I went to graduate school to get a PhD in sociology, I wanted to study the big social institution of education. And what I was really curious about was, we know that there are lots of inequalities that come into schools, like social class inequalities, for example, and we know that they come out on the other side often. And so I was curious about what it was that the institution was doing that was making that worse sometimes, or that at least wasn't acting on it. Like, why would you have an institution that is accessible to everyone that wasn't equalizing? So that was sort of my question that I went into graduate school with. And I ended up not studying education. I ended up writing my dissertation on the careers of lawyers and the way that they had changed between the mid-70s and the mid-90s. And as I was doing that, I started to think about another big social institution that I hadn't really thought about much at all, which was law. And my first question was sort of, well, if you look at lawyers in the United States and also in many other countries, it's kind of weird that law is a public institution, but you have to go pay a private third party, an attorney, to use your own public institution that you've already constituted by electing legislators who write the laws, and you've already paid taxes to fund that public institution. Why is it so complicated that you can't possibly just use it? I mean, there's the way in which that's kind of puzzling to me. But also, if it's a big public institution and it's supposed to be open to everyone, I began to think about how is it then, people are really, really diverse. There are lots of different things that we all bring to our justice issues and to institutions. How could we start to think about ways to design institutions so that they were responsive to that diversity? So that instead of sort of processing inequality and either making it worse or keeping it the same, it was actually less on the other side. So that when people came in, their needs, which might be different, they might need different kinds of things to deal with the same justice issue, those needs could get met by that institution. So that was how I got on this path.
Mais alguém, gente? Fala seu nome.
Good evening, Professor. I'm Bia. I'm also a law student here. First off, thank you for the great presentation. And you mentioned, and we all know here, how elitist law is, with people not knowing many of their rights or legal issues. And here in Brazil, it's 5 years of law school. And then in the US, it's you need to have a degree first and then 3 years of law school. And I wanted to ask if you think that law clinics can help law mitigate its classes to elitist origins, either for the people practicing law or the people being benefited from it.
That's a great question. I think that they can. And I think one of the things that I heard at the beginning of the session that we're in together was that your clinic had been in communication with different groups in the community just today. And I think that's a really important sort of thinking about ways to let people be the authors of understanding what their important problems are, and to be co-creators and ways of acting on them is a way of trying to dissolve some of the eliteness of law. I think that in terms of lawyer training, things that help lawyers think about experiences from the perspective of the people that they might work with are a way of bringing the sort of reducing the distance, I think, between attorneys and the communities that they might try to serve. I also think, you know, one thing you may be aspiring to do in your clinic is like change the profession, right? So to give people the inspiration and encouragement and skills to do different kinds of law than they might have done if they hadn't come through the clinic. And I think that's another way that the legal profession can be reshaped. If you all go through this experience and you end up doing different things than you would have done, things that are supportive of democracy, things that are supportive of equality, that changes the profession, but it also changes the world of the people that you're working with. So I think there's enormous potential here for clinics.
Mais alguém? Professor, thank you so much. It was wonderful to hear you at this event. We truly hope we can continue our dialogue with you on a people-centered approach to access to justice. Thank you so much.
Thank you. It was an honor to be with you, and I really enjoyed the conversation.